Next, from the state capitol, we attend a House floor debate over whether to pass the Equal Rights Amendment. The amendment, which prohibits discrimination based on sex, passed the Illinois House and now needs ratification from one more state before it potentially becomes part of the U.S. Constitution. This runs about 30 minutes.
When our founding fathers, and there were no founding mothers, founded this country, different types of people were not treated as full citizens. African Americans were not treated as full citizens. Women were not treated as full citizens. It wasn't until many, many years later when we finally put an amendment into the United States Constitution that gave women the right to vote that women are even mentioned in the Constitution. Today, despite the fact that we've made efforts in this state and in other states with legislation on equal pay, on equal treatment, the United States Constitution, as written today, would allow us to repeal any of those laws without regard to discrimination against women. Here in the state of Illinois, the 1970 Constitution protects women. And all of the things that the opponents to this resolution are going to talk about in the next 10 or 20 or 30 minutes, all of those horror stories that are about to come forth have not happened in the state of Illinois under our state constitution. Supreme Court justices as far apart politically as Ruth Bader Ginsburg, arguably the most liberal member of the United States Supreme Court, and the late Antonin Scalia, they both agreed that women are not protected by the most important document in our country. Some of the people who will argue against this today continually talk about the importance of the United States Constitution as a core document in our country, and yet are not prepared to add women, 161 million American citizens, to the United States Constitution. Justice Scalia said, certainly the Constitution does not require discrimination on the basis of sex. The only issue is whether it prohibits it. It doesn't. Ladies and gentlemen, there are only 7 countries in the world, 7 countries in the world that have not ratified the International Women's Treaty. Iran, Somalia, Sudan, South Sudan, Palau, Tonga, and the United States of America. If you don't think there's something wrong with that, I don't think you're thinking too clearly. Ladies and gentlemen, you will hear on the floor today discussions about the congressional deadline. Well, the congressional deadline is a deadline that can be changed. They changed it once, they can change it again, as they did with the Madison Amendment, which was ratified 203 years after its actual deadline. The deadline can be changed by Congress. You're going to hear about abortion, about same-sex bathrooms. You're going to hear about co-ed military dormitories. You're going to hear about co-ed prisons. And you're going to hear about boys and girls losing their sports scholarships. Silliness. The Equal Rights Amendment has nothing to do, ladies and gentlemen, with any of those things. Now, I've noted in the debate that has been going on for some time that most of the debate seems to center around abortion. In fact, almost all of the testimony in committee that opposed this resolution was about abortion. Ladies and gentlemen, there have been no issues in the state of Illinois with our equal rights language in our Constitution about the issue of abortion. And you know, when Alice Paul wrote this in 1923, this very same language that we will vote to ratify today, we did not have legal abortion in America. Alice Paul was not talking about abortion. Alice Paul was talking about giving half of the population access to the full freedoms that the American Constitution should afford to them. Ladies and gentlemen, there are many things that can be talked about. For now, let me just say, and I'll say more in my closing, for now, let me just say, this is a historic moment. How often will you get a chance as a member of the Illinois General Assembly to cast a vote that can impact the entire United States of America, the Constitution of the United States of America? We have an opportunity today to be the 37th state to ratify the Equal Rights Amendment for the Constitution.
Generally. And back in the early 20th century, women were pushing for the right to vote. Because of that push, the 19th Amendment to the United States Constitution was passed in 1920. Yet 7 years earlier, action had already been taken in the state of Illinois to give women the right to vote. I referenced Senate Bill 63. Yes, Senate Bill 63 from the 48th General Assembly, because Senate Bill 63 of the 48th General Assembly gave women the right to vote in Illinois. And this is what was said about that vote. With a stroke of a pen, he, the governor, added as many as 1,600,000 new voters. This triumph, the first in a major state east of the Mississippi River, changed everything. As one contemporary explained, quote, "The effect of the victory upon the nation was astounding. Suffrage sentiment doubled overnight." Now, I realize that this is not suffrage, but certainly it has an impact that could be just as great. And I reference that suffrage vote, and I reference where we stand in relation to other states, because I don't believe that Illinois should be a laggard on an issue like this. I think Illinois should be where they were when they passed Senate Bill 63 in the 48th General Assembly, at the head of the pack, leading the nation, and this bill, this amendment, deserves a yes vote. Thank you.
I'd just like to start by reading a few things into the record. Women are already guaranteed full equality in the workplace through Title VII and the Federal Equal Employment Opportunity Act of 1972, which prohibits any sex discrimination in the workplace in regards to hiring, pay, promotion, and establishes the Equal Employment Opportunity Commission to enforce the law. Under the EEOC, women have won multi-million-dollar settlements against the largest companies in the country. Title VII also provides protection and recourse against sexual harassment. This legislation applies to all employers, unions, and government entities. Just going back a little bit in history, in 1973, the EEOC and the Department of Labor and the Department of Justice and the nation's largest private employer signed a landmark consent decree to eliminate discriminatory recruiting, hiring, and promotion practices against women and minorities. Under that decree, they distributed millions of dollars to thousands of women and even minority men. In 1974, the EEOC, Department of Labor, and Department of Justice filed suit against the nation's 9 largest steel producers for discriminatory hiring, promotion, assignment, and wage policies directed against men and women. These 9 companies employed a total of 350,000 workers, and the government suit named the Steelworkers Union, the United Steelworkers of America, as a defendant. They agreed to that $31 million in back pay were to be distributed to 40,000 minority women. In 1980, the EEOC issued interim guidelines on sexual harassment, declaring that sex-related intimidation on the job or creating a sexually charged hostile work environment is unlawful under Title VII. Notwithstanding the controversy surrounding the issue, the Commission voted to adopt the guidelines. In 1986, the Supreme Court for the first time recognized that sexual harassment is a violation of Title VII. In 1987, the year that I graduated from West Point, following the EEOC's decision in the federal sector in a case against the Department of Navy, the Secretary of Navy announced a change in policy providing that female civilian employees will be allowed to participate in sea trials on the same basis as males. In 1998, the EEOC resolved 2 sexual harassment suits resolving large classes of female victims. And in 1999, the EEOC resolved another class action sexual harassment lawsuit against one of the country's largest lettuce growers. So what you see here is we've made a lot of progress in this area, and we have a number of laws on the books already to protect women. The fact of the matter is that women will not be protected until men decide to protect them and decide to stop the sexual harassment, decide to stop the domestic abuse, decide to stop the sex trafficking, decide in their workplaces when they are in charge that they are going to protect the women under their charge. We have the rules on the books. What we need is great men to stand up and protect women. And this body knows it. Having just gone through numerous instances of sexual harassment being filed, and having already people being fired over the issue by some of the most politically influential folks in the state, we know how to solve this problem of equal rights for women. And men need to be the folks to stand up and solve it, because the rules are on the books. I will reiterate again. I was raised by strong parents, a strong mother, a strong father. I was not denied the opportunities. I was allowed to go to West Point. I was allowed to serve in the military in the capacity that I wanted to. And if generals in the past never realized that women are in combat, then they just did not realize it. But women have been in combat since the Revolutionary War. And so, men, I call upon you to solve this problem. We don't need a defunct law that's been dead for decades to solve the problems of women's issues. We need men to be the strong men and support women as their equals. Otherwise, you're just putting another law in the book, and it won't mean anything.
For more than 2 centuries, women have been fighting to win the rights that they have been guaranteed to others. We need the ERA to prevent a rollback of women's rights and to promote laws and court decisions that fairly take into account women's as well as men's experiences. Unless we put into the Constitution the bedrock principle that equality of rights cannot be denied or abridged on account of sex, and political and judicial victories that women have achieved for the past 2 centuries can be reversed at any time. And we are already seeing that under this current administration. Congress has the power to make laws that replace the existing laws and do so by a simple majority. Therefore, many of the current legal protections against sex discrimination can be removed by the margin of a single vote. We cannot let that happen, and this is our time to protect the progress that we've made and the progress that we can see in the future. This is a very exciting day for me because not only did we bring this forward, but I have my husband and son on the floor with me to see what Illinois can do to move the state ahead. In our household, I have taught my children about equality, and I am equal in our house. Well, maybe sometimes I'm the boss in our house, but I tell them that we're equal. What's important to me is that my family knows that not only am I equal in our home and not only am I teaching them equality, but the Constitution of the United States sees me as their equal, and the law protects me as an equal under our Constitution. It is about time we get this done. 37 is a great number. Let's be the 37th state to ratify the ERA.
I'm appalled by some of the things that I have heard. I'm appalled, just as Representative Flowers was, by the sponsor's opening speech, where he had the audacity to mention race. And this, we all know that this bill does not affect women that are black, brown, or any other color. This bill actually takes us 4 steps backwards. It does not in any way, shape, or form benefit a woman of color. It does not. Individuals have stated that they read the language. Well, obviously, you didn't comprehend what it was that you read. Representative Morrison is right. The language matters. What is in this particular bill, these few little words, as it was just stated, they have a significant impact on what they are going to do to the individuals. This bill is a bad bill. I'm sorry. It is wrong for Illinois. It is wrong for every single one of us in this chamber. We are pushing language that was written in 1923. We have come a long way since then. Racial relations have come a long way since then. If you look at this constitutional amendment, if you look at the language in our own Illinois Constitution, Illinois is backwards. Alaska has a more progressive constitutional amendment than Illinois ever will, because they acknowledge race, they acknowledge ethnicity. You know, we heard words like equity and equality. Well, this bill doesn't give it to us. It actually takes it away. The language in this bill, those few little words that everybody thinks are just so inconsequential, what do they really do? They supersede the 14th Amendment. They take away that racial equality from us. This is what Representative Flowers was trying to explain. This is what was being ignored. When I brought this matter up to the sponsor, he told me, he acknowledged that this bill would take away my rights, but told me to vote for it anyway. Why in the world would I vote for a bill that would take away my rights? I am a mother. How can I stand on this floor and go home and tell my daughter that I voted for a bill that would subject her to becoming a second-class citizen? I absolutely cannot, and I will not. And anyone that says anything differently did not read and comprehend what it was that this bill will do. This is a horrible, horrible act. It will not take us into the next century. It will take my people 4 steps back. I recommend a no vote.
We are different. We are objectively different. That doesn't mean that we should have different rights. It just means that the law recognizes the differences between men and women, and those are reasonable, understandable, common sense differences, and we see that reflected in our federal and state laws. But according to this flyer, it says the ERA provides a fundamental legal remedy against sex discrimination for both women and men. The problem is, as we have seen in the last several years, that there will be men who will claim discrimination for not being able to participate on certain women's sports teams or receive certain scholarships that have been set aside for actual women. And if you have the hammer of the ERA, that those protections would go away, those protections for women. Furthermore, according to this flyer, the ERA would require the courts to judge sex discrimination with the highest constitutional protection of strict scrutiny, now used for religion and race. So we had a bill not long ago, now a law, now being challenged in the courts, on the health care right of conscience. There are doctors and nurses, medical professionals, both men and women, who for reasons of conscience, do not want to be involved in the decision of abortion. Well, the law doesn't require them to do that. But with an ERA, it could be argued in court that those individuals are discriminating against a procedure that only women would be seeking. And so imagine a situation, just like we would find it abhorrent that someone would not provide medical care for someone of a certain race or a certain religion, will a doctor or a nurse who has pro-life convictions be charged with discrimination and lose their license because they're discriminating against women for not wanting to do that procedure? We have a women and minority-owned business enterprise provision. Those would go away because that is a set-aside for women. In the 18 states that passed an Equal Rights Amendment, there have not been benefits for women. Instead, the courts have taken away those protections. In Maryland, the court held that the state ERA, a husband could no longer be required to support his dependent wife. In Pennsylvania, a father was exempted from providing support for his minor children, and a husband's legal responsibility for his wife's hospital and medical bills was nullified. And finally, think about insurance rates. They're set based upon the differences in sex. For health, life, but also things like automobile insurance. Women are typically better drivers. They would not be able to get preferred rates. But keep in mind, when the ERA was first introduced in 1972, there were quickly about 20 states that ratified it. In 1973, there were another a dozen, maybe 15 states that quickly ratified it. Well, what else happened in 1973? The Supreme Court handed down Roe versus Wade. And that's why the movement on ERA dramatically slowed down, and it stopped. And actually, there are 5 states that have tried to rescind their ratification of ERA. That should tell us something.
From the beginning, we had women in the military who dressed as men so they can serve. We had World War II women who were told you can only get to the rank of lieutenant colonel because the rank of colonel and above was only for men. All this, thankfully, through the years, women has persevered in order to get up the ranks in the military and in order to now finally be able to serve in the capacity in which they are very competent in serving. I am appalled and embarrassed that the state of Illinois has not done this earlier.
The ERA would stand in the way of sex discrimination in the military, ensuring that women are able to serve their nation to the best of their ability and to advance through the ranks alongside men. And this is particularly important for African American women who enlist in the military at significantly higher rates than white or Hispanic women. The ERA could have immediate practical consequences for teachers and the millions of women who work for the agencies of the state, federal, and local government. Passage of the ERA should prompt all government employers to examine their pay and promotion practices to make sure that they are equal, and to evaluate their protections for pregnant employees as well. At the same time, the ERA would not abolish all sex-based distinctions under the law. It would merely subject them to greater scrutiny in court. If the distinction serves a compelling state interest and is narrowly tailored to serve that goal, it would be allowed to stand. And it's important to note that a number of race-conscious policies have been allowed to stand under strict scrutiny, including policies that take race into account in college admissions. As I make these comments, I do so standing on the shoulders of my mother, Velma Wiggins, my grandmother, Velma Slaughter, and my great-grandmother, Anna Capshaw, none of whom lived to see this historical vote, but left a legacy that I should value all people as equal and spend my days working for the same. And standing on my shoulders are Tyler, Cassidy, Ryan, and Mackenzie, and my hope is that their rights are also protected under the United States Constitution as being equal to those of their male counterparts. For those strong women who have gone before us dreaming of a better tomorrow for their daughters, that tomorrow is now here. And for the girls who are the strong women of our future, the hope of their tomorrow begins right now. But also, for all of the men and the boys who also stand for and are being raised to value justice and equality for all, we can and must act for them as well. As a woman, and as a black woman in particular, I have experienced discrimination, not just from being a woman in America, but also from being a woman of color. And we are certainly not where we need to be in this country, but I have radical faith, and I have not given up hope as to where we can go from here. But I truly do believe that our Constitution, that living, breathing document that guides us and sets forth the ideals of this country, must reflect what we hope to be and serve as our compass.
Take a step back from your politics, people. Take a step back from this group that you're worried about and the next primary that you're concerned about and who's coming after you from the left and who's coming after you from the right and the phone calls you get from angry people. We're better than that. We are better than that. Women aren't being paid enough. Women are being mistreated in courtrooms. Women can't sign car leases without a cosigner. Women can't get an apartment without a cosigner. Women can't find jobs because men say, well, you might quit to have a baby, so you shouldn't be working here. This is 2018. Don't we have a heart? Don't we understand? I think we understand. This body, 118 people in this room today, have a chance to change the United States of America. And the question is, will we take the time to do it? Will we search our hearts and our brains and put aside the things that separate us and get together and do the right thing for the people of the United States of America? We will never get this chance again. This is it. 8:00 p.m. on May 30th, 2018, we have a chance to make the United States of America, all the country, a better place. Are we going to do it, or are we not going to do it? And before I sit down, to those who said to me, I'll be your 71st vote, I'll think it over, don't be the 71st vote. Be the first vote. Put your green vote up on the board, do the right thing, and watch the totals grow, because if everybody who told me they'd be the 71st vote votes for this, we will pass this right now. Please vote aye.
The gentleman moves that the House adopt SJRCA 4. All those in favor, vote aye. All opposed, vote nay. The voting is open. Have all voted who wish? Have all voted who wish? Members, please record yourself. Have all voted who wish? Mr. Clerk, please take the record. On the count of 72 voting in favor, 45 voting against, and 0 voting present, SJRCA 4 is adopted.